wham, that denial letter hits your mailbox. That feeling, it can be absolutely daunting, right? Especially when you're already trying to figure out a system as complex as the Office of Workers' Compensation Programs, or OWCP. But what if you had a clear roadmap, like a shortcut to understanding exactly what your options are? Well, that's really our mission here at Deep Dive. Cut through all that complexity, and deliver crucial, actionable knowledge right to you. So today, we're taking a deep dive into the OWCP claim denial appeals process. This is all under the Federal Employees Compensation Act, ECA. And our source material for this is, it's a really comprehensive guide. It outlines the appeal options, the timelines, best practices, everything you need.
Yeah, and what you're going to walk away with today isn't just like a dry list of facts. It's going to be a really clear understanding of the three main ways you can appeal. We'll break down their specific rules, the strategic choices you need to make, and the goal is, by the end, you won't feel overwhelmed. You'll actually feel informed, empowered to deal with this.
Okay, let's unpack this then. When an OWCP claim gets denied, you've got three distinct avenues for appeal.
Illness from your job,
but here's where it gets really interesting right off the bat. You might think, okay, I'll just try all three, or pick the one that sounds best. But nope, that's absolutely not how it works.
Exactly. That's fascinating, isn't it? This one-at-a-time rule is absolutely fundamental. You have to choose only one of these three options for the same OWCP decision, which, right away tells you there's a strategic choice to be made from the very beginning. Pick the wrong one, or try to do too much at once, and you can really shoot yourself in the foot.
Okay, so you're at this crossroads. What exactly are the three doors you can choose?
Right. The three options are, first, you can request an OWCP hearing, and that can be an oral hearing, usually phone or video, maybe in person. Yeah, and what you're going to walk away with today isn't just like a dry list of facts. Second, you can request reconsideration by OWCP understanding of the three main ways you looking at new evidence, break down their specific rules, and third, you can file an appeal to the Employees Compensation Appeals Board. You won't feel overwhelmed. You'll actually feel informed, empowered.
That one-at-a-time rule you mentioned. Okay, let's unpack this then. When an OWCP claim gets denied, you've got three distinct avenues for appeal.
Well, it's not just a guideline.
But here's where it gets really interesting right off the bat. You might think, okay, I'll just try all three, or pick the one that sounds best. But nope, that's absolutely not how it works.
Exactly. That's fascinating, isn't it? This one-at-a-time rule is absolutely fundamental. You have to choose only one of these three options for the same OWCP decision, which right away tells you there's a strategic choice to be made from the very beginning. It can be the wrong one, or try to do too much at once, and you could really shoot yourself in the foot. So let's start with those initial, really critical deadlines.
What exactly are the three doors you can choose?
A hearing request. Right. Needs to be three options are, 30 days of the decision. You can request a reconsideration request hearing, that has to be filed and that can be an oral hearing, usually phone or video, filed within maybe in person sometimes, or just a review of the written record.
So the guide stresses
Second, you can request reconsideration by OWCP.
Life happens. Is there really zero wiggle room? Like any extreme super rare exceptions where lateness might slide?
And third, you can file an appeal to the Employees Compensation Appeals Board. For the 30-day hearing deadline and the 180-day independent independent deadline, honestly, there's
that
almost no
one-at-a-time rule you mentioned, it sounds absolutely critical, but the one-year deadline people might feel desperate. Why can't they just try all three?
It does have a very narrow exception for what it's not just a clear evidence of error. If you try to pursue two options, you basically have to show OWCP made an obvious glaring or ECAB. So really, the best advice is assume they're non-negotiable. They'll say it's premature, filed improperly. Knowing that right up front lets you act decisively doesn't really risk losing your appeal rights.
So let's say someone feels like their story just wasn't heard, right? They want that direct interaction.
If you miss them,
our guide suggests a hearing might be the way to go. What does that actually look like?
Right. So let's start with those initial, really critical branch of hearings and review, and it's especially good when there are needs to be postmarked factual 30 days involved. Like maybe there's a question about exactly how the incident happened, or if witnesses really back up your story. Your testimony under oath can really clear up misunderstandings.
So the guide stresses these deadlines are absolute. And the clock starts immediately on this one. The guide really hammers this home. Any extreme super rare exceptions, you must send a written hearing request, postmarked within 30 calendar days of that OWCP decision date. That postmark is key. It proves you were on time. Miss it, and you forfeit your right to a hearing.
The one-year deadline for reconsideration. And when you request a hearing, there are two flavors. You've got the oral hearing, that's where you appear, usually by phone or video, sometimes in person. It's pretty informal, not like a courtroom drama. You get to speak. speak, present evidence, give testimony under oath, even bring witnesses. They usually audio record it, and it's typically limited to about an hour, so you need to be prepared. Then there's the review of the written record.
So
for this one,
no
personal
feels
appearance.
like their
You just send
story
in a
just
written
wasn't
statement,
heard, right?
plus
They
any
want
new
that direct
evidence, and a
interaction.
hearing representative reviews everything in your file.
Okay, you mentioned after an oral hearing, there's an extra 30 days to submit more evidence.
This option is handled by OWCP's own branch of hearings.
What kind of stuff usually comes up during a hearing that makes people need that
factual
extra time?
disputes involved. That's like maybe there's a question and it really is a critical advantage. Or often during the hearing, the representative might ask questions that suddenly shine a light on a specific gap in your medical evidence. Or maybe they'll mention a legal standard.
And the clock starts immediately on this one.
Something like,
the guide really hammers this home.
From your doctor about
you must send a written hearing request, postmarked within 30 calendar days of that OWCP
that original
decision
witness
date.
statement.
That postmark is key.
Detailed enough on this
proves you were on
that
time.
That 30-day window is your chance to scramble, go back to your doctor or that witness, and get exactly. And when you request a hearing, there are two flavors. You've got the oral hearing. That's where you appear, usually by phone or video, sometimes in person. It's pretty informal, not like getting the oral hearing scheduled. Can take anywhere evidence, give testimony under oath, even bring witnesses. Sometimes usually things are backed up. It could even be 6 to 8 months. And it's typically limited to about an hour, so you need to be prepared. The hearing happens or the record. Then there's the review of the written decision itself. For this one, no personal appearance. You just send in a written statement. Plus any new evidence, and a hearing representative reviews everything in your file.
Okay, you mentioned after an oral hearing, there's an extra 30 days to submit more evidence. That sounds huge. What kind of stuff usually comes up during a hearing that makes people need that extra time?
That's a great point, and it really is a critical advantage.
Okay, so knowing all that, what are the best tactical moves? What does the
ask
guide say are the best practices for hearings, and what are the common traps people fall into?
Right. Or maybe they'll mention a legal standard you hadn't quite addressed fully. Send your request on time. Look, we don't have a clear certified mail or the ECAB portal why the specific work task caused this condition. Or maybe that original witness statement. Oral is often better if facts are disputed, so you can actually tell your story and answer questions directly. Go back to your doctor or that witness and get exactly what's needed to fill that gap. Get witness statements for injuries, detailed job descriptions if it's an occupational disease claim.
How long does this process usually take?
A detailed narrative medical just getting the oral hearing scheduled can take anywhere from, say, 3 to 6 months.
How your work actually
sometimes, if things are backed up, it could even be 6 to 8 months. If you choose an oral hearing, then after the hearing happens, outline your main points, stick to the decision itself, and make sure you address the specific basis for denial they gave you in the letter. So overall, remember, you're probably only got 6 to 8 months for the whole hearing process to play out and get a decision. Although there is a possibility of a summary decision. It's a golden opportunity to submit follow-up reports if you submit really strong evidence.
Okay, and what about the classic mistakes? What should people absolutely avoid? Okay, so knowing all that, what are the best tactical moves? What does the guide say are the best practices for hearings, and what are the common traps?
Another one is not including new evidence. Let's talk strategy. Best practices first. Number one, hearing rep isn't send your request on time. Original decision. Use certified mail or the ECAB portal online. Just a lack of preparation for the oral hearing. That's your chance. Specify oral or don't wing it. Oral is often better if facts are disputed, so you can actually tell your story and answer questions directly. If you miss that 30-day window, prep your evidence carefully. Get new evidence for injuries, detailed job descriptions if it's an occupational disease claim, and this is key.
If the main issue is really about the evidence itself, especially medical evidence, or maybe you have a specific legal point, our guide suggests reconsideration.
Exactly. And if you choose an oral hearing, practice your testimony. For reconsideration. Outline your main points, stick to the facts, and make sure you address the specific basis for denial they gave you that handled your claim. Remember, you've probably only got about an hour. You're asking them to take another look, but finally, like we just discussed, really leverage that 30-day post-hearing window. You're essentially saying, hey, here's something important you didn't have before, or maybe you overlooked this point.
Okay, and what about the classic mistakes?
The deadline here is a bit more generous within 1 year of the decision date.
The most frequent
but
fatal
as you
error
pointed out, it has to be received by OWCP within that year.
It's so strict.
So mailing it
Another
on day
one is not
365
including
is
new
cutting
evidence
it way
if you
too
choose a
close.
written
Get proof
record
of receipt.
review. Yeah, absolutely. The hearing rep isn't going to overturn the original decision without something new. What kind of new stuff do they need? It can't just be anything for the oral hearing. Our guide points straight to the regulation. It's 20 CFR section 10.606B if you want post-hearing evidence. But basically, OWCP needs you to show 30-day window after the oral hearing. One, your new evidence, no matter how good it is, or interpreting the law. Won't be considered. Two, that you have a relevant legal argument they just didn't consider before.
Really about the evidence itself,
or, and this is the most common one, that you have relevant, pertinent, new evidence they haven't seen yet.
So again, just saying I disagree isn't enough.
That's
you have to bring something new and relevant to the table, not just duplicates of what they already have, or stuff that doesn't actually address why they denied you.
Exactly, and when you submit this request, a different claims examiner someone not involved in the original denial. It has to be based on either new evidence or new legal arguments. First, they decide if your request even meets those criteria we just talked about that's called the threshold review, or maybe you overlooked this point of law.
And the deadline here is a bit more generous within 1 year of the decision date. But as you pointed out, it has to be received by OWCP within that year.
What are the possible outcomes?
Mailing it on day 365 is cutting it way too close.
You could get a merit decision. Yeah, this means they've reviewed the substance. And this brings up a key question. They might affirm the denial, what kind of new stuff do they need? It can't just be anything. If they reverse or modify, our guide points straight to the regulations, 20 CFR section 10.606b if you want the specifics. Or you might get a non-merit decision. OWCP needs you to show decided your request didn't meet the threshold. Maybe that they clearly messed up applying, so they refused to reopen the case. And the prior denial that you have a relevant legal argument they just didn't consider before. You can appeal that non-merit decision itself. Or, and this is the most common one, that you have relevant, pertinent new evidence they haven't seen yet.
So again, just saying I disagree
significantly
isn't
quicker
enough. You
usually.
have to bring something new and relevant to the table.
OWCP generally aims to get a decision out within about 90 days, so roughly 3 months from when they receive your request. And when you submit this request,
what if you missed that
different
1 year
claims
deadline
examiner,
for
someone not involved in the original
Is
denial,
it game over then?
First, they decide if your request even meets those criteria we just talked about. If you miss that 1 year mark, the standard for getting them to even look at your request goes way up. OWCP will only consider an untimely request if you present what they call clear evidence of error in the last decision. And that is a very tough standard. You basically have to prove their decision was just flat out wrong. This means glaring, undeniable mistake. Our guide is crystal clear. Do not count on meeting this completely or modify it. It's much better to get something new in before that 1 year deadline. Untimely requests rarely succeed under this higher burden.
Okay, understood.
Or
so
you might
for
get a non-merit
reconsideration,
decision.
let's talk best practices and common pitfalls.
This means they decided your request didn't meet the threshold. Maybe you didn't provide number one best practice. So they refuse to reopen the basis for denial from their letter. But importantly, use their reasons. You can appeal that non-merit decision itself, for instance, no causal medical opinion.
The guide suggests reconsiderations are generally quicker than
detailed
hearings.
narrative report from your doctor, significantly quicker usually. OWCP generally aims to get a decision out within about 90 days, so roughly 3 months clearly from when they receive your request letter.
But okay, what if you missed that 1 year deadline for reconsideration?
And
is
say
it game
whether
over
you're
then?
providing new evidence,
Any
arguing
hope
law,
left?
the missed deadline.
Counts, right?
If you missed that 1 year mark, the standard for getting them to even look at your request goes way up. OWCP will only consider an untimely request if you present what they call clear evidence of error in the last decision. And that is a very tough standard. You basically have to prove their decision was just flat out wrong, like a glaring, undeniable mistake. Our guide is crystal clear. If you're just waiting on one last crucial doctor's report, maybe it's much better to get something new in before that 1 year deadline. Get that initial request. Untimely requests rarely succeed under this higher burden. The biggest mistake is just sending a letter saying,
for reconsideration, let's talk best practices and common pitfalls again.
Just disagreeing.
What should people focus on?
That's not enough. You must include the new evidence or the new argument. Target the basis. Another common one is just rehashing old evidence. Use their reasons as duplicates or slightly reworded versions of things they've already seen. No causal medical opinion. Also, submitting irrelevant
Get
a strong, detailed narrative focused on evidence that directly addresses the reasons they denied you. Worsened your condition. And as we stressed, missing the 1 year deadline. State your specific grounds. That really puts you behind your request with the clear regulation standard. Finally, not reading the reconsideration decision carefully and say whether you need to know if new evidence, arguing law, which has new appeal rights, or a non-merit denial, which you can appeal. Organize your submission. That use a cover letter, list your attachments, and briefly
third and final
explain
administrative
each new piece of
path.
evidence is supposed
If you've
to
maybe
prove
tried the other
and how it
options,
tackles the
or perhaps you
denial
feel your case is already strong based only on what's in the record right
focus
now,
on relevant,
our guide
substantive
points
new
to
info,
ECAB.
not just bring them in paper. The employee's compensation appeals
get it in
board,
within
ECAB. If you're just waiting on one last crucial doctor's report, maybe send the request on time saying the report will follow the Department of Labor, but get that initial request from the OWCP district
and the mistakes to
offices.
avoid.
The biggest mistake is just sending a letter saying, please reconsider. Its job is to see if OWCP got it right based on the law and the facts that were already in the case file when OWCP made that Another common one is just rehashing
here
old
is
evidence.
the absolute most
Sending
critical
duplicates or
distinction for
slightly
ECP, the one
reworded
that
versions
trips
of
people
things
up
they've
all the
already
time.
seen won't cut it.
It does not allow new
Also,
evidence.
submitting irrelevant
Zero.
stuff.
Nada.
Keep it focused on
ECP
evidence
will
that
only look at the
directly addresses
documents,
the
the
reasons
evidence,
they
the
denied
arguments that were in your OWCP
And,
case
as we
record
stressed,
at the time
missing the
OWCP
1 year
issued the decision
deadline.
appealing.
That
So if you
really
have new
puts you
evidence,
behind
a
the
new
8
doctor's
ball with the
report, a new
clear
witness
evidence of
statement,
error standard.
ECAB is almost certainly
Finally,
the wrong
not
place
reading
to
the
go first.
reconsideration decision
Reconsideration
carefully.
with
You need
OWCP
to
is
know
where you
if it was a
submit new
merit
stuff.
decision,
This is a huge
which has
strategic
new
point.
appeal rights,
Absolutely huge.
or a
And the deadline for
non-merit
ECP
denial,
is also
which you can
strict.
appeal to
You have to file your appeal
That
within
dictates
180
your next
days,
step.
so about 6
Okay,
months.
on to
from
the
date of
third
that
and final
OWCP
administrative
decision you
path.
want reviewed.
If you've
Miss
maybe
that
tried the
deadline
other
and your
options,
appeal will almost
or perhaps you
certainly be
feel your
dismissed.
case is already
Very
strong
little
based
wiggle room
only
there
on what's
either.
in the record
So what
right
does
now,
ECAB
our
actually
guide
look for
points to
then,
ECAB.
if not new
Right.
evidence?
They're
The
primarily
employee's
looking for
compensation
errors,
appeals board,
errors of law or
ECAB.
errors of
Think
fact
of it
as the highest court of appeals within the OWCP Did OWCP follow the right procedures? Did they interpret the FECA statute or the regulations correctly? Was their final decision actually supported by the weight of the evidence they had in front of them at the time? It's very much a review based on the law and the facts that were already in the case file when OWCP made
And what about the
that final
timeline
decision.
for ECK? Is it faster or slower?
Oh, definitely the slowest of the three options, by far. You need to be patient here. Expect decisions to take anywhere from several months to, honestly, sometimes over a year. A common time frame seems to be maybe around the 9 to 12 month mark.
Wow, okay, so after ECKB rules, is that it? Is that the absolute final word?
Well, it's the highest administrative appeal. Generally speaking, federal courts don't have jurisdiction. They can't review FECA claim decisions on the merits. So, yes, the ECKB and the deadline for ECP is also final in that sense. You have to file your appeal within 180 days. However, and this is a really important nuance our guide highlights, even after that OWCP decision, OWCP can still potentially look at a new request for reconsideration later on if you obtain truly new and relevant evidence that wasn't available before. They're primarily looking for errors. Errors of law or errors of fact based on the existing record. Did OWCP follow the right procedures? Did they interpret the FECA statute or the regulations correctly? Was their final decision actually supported by the weight of the evidence they had in front of them at the time? It's very much a review of the decision-making process and the record, often as a last not a whole new investigation. If you have new evidence,
and what about the timeline for ECK? Is it faster or slower?
Oh, definitely the slowest of the three options, by far. You need to be patient here. Expect decisions to take anywhere from several months to, honestly, sometimes over a year. A common time frame seems to be maybe around the 9 to 12 month mark. Legal or factual error they made based on that record.
And if you do go to ECAB,
well, then prepare a focused, strong argument. Don't just fill out the appeal form and hope for the best. Write a clear letter or even a short brief explaining exactly why OWCP's decision was wrong. Point out the specific errors. However, did they ignore key evidence, misinterpret the law, rely on a medical opinion that was flawed or insufficient? Point ECB directly to the documents and page numbers in the case file that support your argument. And of course, meet that 180-day deadline. Fill out the form correctly, use tracked mail or file electronically, get confirmation.
And the mistakes people commonly make with ECK.
A major one, as we said, is filing an ECB appeal when you actually had new evidence
available. Okay, so let's wrap up ECK
that just ties your hands because ECKB can't look at it. Always prioritize reconsideration if you have new, relevant often as a last resort. If you have another error is trying to pursue multiple appeals at once. Remember that one at a time rule. Don't waste your ECKB shot. Cannot have a reconsideration pending, and an ECK is really best when you strongly believe the existing record already proves your case. One path, then potentially the other if needed, or when you can pinpoint the clear legal or factual error they made much shorter than the reconsideration
deadline. And if you do go to ECAB,
then prepare a focused, strong argument. Don't just fill out the appeal form and hope for the best. Don't just write a clear letter or even a short brief explaining exactly why OWCP's decision was wrong. Point out the specific errors. Did they ignore key evidence? Don't expect them to be misinterpret the law. Rely on a medical opinion that was flawed or insufficient.
So we've gone through the three main avenues.
Point ECB directly to the documents and page numbers in the case file that support your argument.
What does this all mean for you facing a denial?
And of course, meet that 180-day deadline. Fill out the form correctly, use tracked mail or file electronically, get confirmation.
And the mistakes people commonly make with ECK.
A major one, as we've said, is filing an ECB appeal when you actually had new evidence available. And also realizing it might be that just ties your hands because ECKB can't look at it.
So connect the dots for us.
Always prioritize reconsideration if you have new relevant information. If the core issue is error is trying to pursue multiple appeals at once. Remember that one at a time rule. You then an oral hearing cannot have a reconsideration pending and an ECKB appeal pending on the same OWCP decision. If the problem is primarily the medical evidence, potentially the other if needed, missing the 180-day deadline reconsideration is often much shorter than the reconsideration deadline. Rationalized medical opinion they need. And finally, just submitting subpar argumentation or misinterpreted don't just file the form and say they were wrong. And you don't have new evidence. Explain why they were wrong. ECP is the place to challenge that interpretation. ECKB needs specific errors identified to justify overturning a decision.
And the recurring theme we kept hitting on was the absolute importance of deadlines. Yes, so we've gone through also the strategic use of new evidence, reconsideration. Hearings and reconsiderations. What does this all mean for you? Offer that chance to add new information.
The obvious takeaway is that choosing the right appeal path
to getting a denial overturned.
But I think the deeper insight from our guide is that successful claims actually go through multiple rounds of reconsideration, and maybe the first time the new evidence wasn't quite strong enough, and also realizing it might be so the claimant gets an even better doctor's report and tries again.
So connect the dots for us.
Persistence combined with really understanding this process, the deadlines, the evidence requirements for each step, can significantly improve your chances. What actually happened? It's often less about one single appeal And more about strategically building your case over time within the system's rules.
And it's worth remembering, you probably don't have to navigate this maze alone. Union reps, maybe knowledgeable advisors or attorneys specializing in this area, can be incredibly helpful. So wrapping up, you should now have a much clearer picture of the federal workers' compensation appeals process.
And you don't have new evidence,
it might seem incredibly complex from the outside, and honestly, it is complex. Yeah, but we've unpacked those crucial
deadlines. And the recurring
theme we kept hitting on was the vital role of new evidence or the lack of deadlines, yes, but also the strategic choices at each step. Hearings and reconsiderations both staying denied offer that chance to add new information.
Yeah, this whole process really highlights just how critical documentation and timely action are. And it's why many successful claims actually go through multiple rounds. It's not just about being right. It's about proving your new evidence according to their rules and timelines.
Knowing when it's best to speak directly,
when
it's time to submit that crucial piece of new evidence,
combined with really
to challenge the decision based only on the existing record, that knowledge transforms this confusing maze into hopefully a more manageable path forward.
And more about
really empowers
building your case over
maybe
time
a final thought to leave you with.
And it's worth remembering, you probably don't have to navigate this maze alone. Union reps, maybe knowledgeable advisors or attorneys specializing in this area, can be incredibly helpful. So wrapping up, you should now have a much clearer picture of the federal workers' compensation appeals process. It might seem incredibly complex from the outside,